Good morning.
Good morning.
Thank you. Good morning. You may proceed.
Thank you, Your Honor. Good morning. My name is Andrew Crouch, and I represent the appellant Thomas Knowles in his appeal from the Malden convictions out of the Malden District Court. I do appreciate this court allowing us the opportunity to rehear this case before the full panel. As you know, we were here back in March. I won't belabor the facts too much, but just to go over them slightly as they pertain to the case. This is a case involving an unknown individual making a phone call to the Malden Police Department, informing them that there was an individual at a specific location in the city of Malden swinging a baseball bat, wearing a white T-shirt and blue jeans. That was the full extent of the call. There was no allegation the person was swinging a bat at any other person or engaged in any other criminal activity. That is primarily the focus of what we're here to discuss today. Without getting too much further into the facts, and I'm sure that will be discussed during the argument, I'd first like to address the issue of whether or not there was a seizure involved. As this court knows, in determining the scope of an intrusion and whether or not that's reasonable, the first thing that a court must do is determine the propriety of the initial contact. And that is crucially important, because if a seizure is found to have occurred in this case, a certain standard applies. If a seizure is found to not have occurred in this case, a different standard could potentially apply, or we have to look at other potential bases on which Officer Mann could justify the interactions that he had with Mr. Knowles.
Let me ask you this. What if the police officer had not said anything, excuse me, to the defendant, but had just seen them, whatever it was, thank you, in the trunk? Would his plain view observations have been improper?
It would depend, I think, at first in how the interaction took place. If he had just walked up, if he had been just walking past the car and seen what was in the trunk, I think that plain view probably would apply. In this case, as your honors know, he is 50 feet away. He turns his car diagonally across the street, and it is when the individual takes something out of his right pocket and throws it into the trunk. From that distance, he then freezes the Officer Mann freezes the scene, and then it's only after he freezes the scene that he comes into some sort of contact with
You're arguing that the placement of the car was the seizure?
I'm saying in the brief, I do argue that, and I know that case law has not advanced to this point yet in terms of the Helm case, that turning diagonally across the street is a sign of a show of authority. If that by itself is not sufficient to justify, because Officer Mann doesn't just pull up to the curb or pull up next to Mr. Knowles' vehicle. He does block the street 50 feet behind the car.
But this is a pedestrian. I mean, 50 feet is quite a distance.
Well, he says 50 feet or less. It's not 100% clear from the record, but it is about 50, within about 50 feet. He pulls the car up diagonally, and then that is the diagonal turn of the car is indeed one part of the seizure.
Is this a two-way street?
Actually, from the record, it's not clear, but Mr. Knowles' car is parked, so conceivably it is likely a two-way street.
Well, doesn't it have to be established before you can say that the car, the way the car was parked, prevented access? Well,
my understanding, he's parked diagonally across the street. He's going to block flow at least one way or the other in terms of how the car is actually parked. But I think...
I'm sorry, please finish.
I think that the more important part beyond the diagonal turn of the car, I think that while that may be open to debate and discussion, I think when we get into looking at Officer Mann's actual wording that he used, and I would point to a case that actually I did not cite in the brief, Commonwealth versus Grandison from this court from 2001, which pretty clearly, it's in that case, the Commonwealth conceded that there was a seizure, didn't even argue that a seizure did not occur, when the officers in that particular
versus what?
Grandison, that's at 433 Mass 135 from 2001. And it was in that case, Commonwealth conceded seizure where the officer commanded the defendant to stop after he was involved in spitting out an item that turned out later to be narcotics. The use of the word stop, use of the word come here, or the word come, those are commands requiring acquiescence under sort of the Mendenhall standard of case line in terms of tone of authority. And as I noted, in Grandison, the Commonwealth didn't even, with the use of the word stop, conceded that a seizure had occurred.
Mr. Crouch, does the record tell us about Whether this was a busy street, whether there were cars parked on both sides, whether there were pedestrians? What does the record tell us?
The record does tell us, and the record says that when Officer Mann gets there, he actually arrives at the specific location where the dispatches come from. He
Right.
looks around and sees no one there.
But he looks around the corner.
And he turns around the corner. He sees an individual, Mr. Knowles, later identified, matching the description. There's still nobody around. There is no testimony about any cars. There is certainly, it is an empty street. Now, as I'm sure Your Honor knows, the motion judge found that it was actually a busy street, and that was central to his decision. The appeals court, along with other errors that the motion judge made, clarified that and said that, indeed, Officer Mann testified that it was an empty street. There was no one around. This is the point where seizure occurs. If no later than when Officer Mann says the word stop, and when he says the word come here, when he says specifically, ordered the defendant to stop where he was, stop at this time, and then to just come towards me, and to keep his hands out of his pockets and start walking towards me. These are situations in words and a tone that no reasonable individual would think, they were free to leave the scene at that point.
So what's the status of reasonable suspicion at that point?
At that point, what Officer Mann has to go on is there's only two possibilities. The first possibility is what brought him to the scene, which is the police dispatch for a man swinging a bat. The motion judge doesn't find that that's criminal behavior. The appeals court says that it's not indicative of outright criminal behavior, which I think, or criminal activity, which I think you either have criminal activity or you don't have criminal activity. That falls short. That is what he had first off, was the swinging a bat, which I don't think an argument can be made that that is actually any sort of a criminal activity, short of having other people around, having it being swung at anyone else. The record doesn't show any facts like that. The second point is the action that Mr. Knowles took when seeing the individual throwing, which the appeals court found was not a furtive gesture, and also the motion judge did not find that that was a furtive gesture. Those are the two sole bases on which a finding can be made.
But didn't the motion judge find not furtive, but that it was something that would give rise to a fear for officer safety?
It was an issue. It was certainly an issue raised that, and the appeals court said the same thing, that it was an issue that raised some sort of a concern or heightened the officers, looking in on the individual, seeing that action, those two actions. But the question becomes here, and this is why I initially said it's important to determine the propriety of the initial intrusion. Once we find seizure, there's a very strict standard that needs to be followed, and that standard is whether or not there is reasonable suspicion of criminal activity.
But I asked, arguably the seizure was for the officer's safety. This stop and get away from the baseball bat. Does a police officer ever have a right to say to somebody who he only can go up and talk to on a non-compulsory basis, no indication of any crime, if the person is holding a baseball bat in his hand, and the police officer just wants to talk to him, can the police officer say, I would like to talk to you, put the bat down?
These are the cases that talk, such as cases like Fraser. I think that Fraser case and its progeny, mainly the cases that come out of the appeals court, are cases short of reasonable suspicion of criminal activity, short of probable cause, in which an officer does have a limited right under certain circumstances. And it's important to note that where there is no seizure, there is no basis of criminal activity, which by itself starts raising the bar in terms of potential dangerousness, potential officer safety. Here, the specific standard that needs to be applied from the Fraser case is one where it's not a standard of whether the officer's actions were a reasonable and prudent safety precaution. That's not the standard. It's not that officers are allowed in that situation to take reasonable safety precautions. It's whether or not the officer had reasonable belief that the defendant is armed and dangerous. And in this case, that is the only standard in which the officer can then engage in a seizure, engage in a pat frisk, and I would note specifically, this court's cases and the cases of the appeals court are very limited in this respect.
Also, in the Fraser case was an armed weapon of some kind. That was a gun.
It was a gun.
Yeah, which is a little different. That is to say, the police officer could, for example, remain in his car and say, in other words, if you view the baseball bat as a weapon, you know, there are all kinds of things that can be swung at a police officer. But it seems to me the gun is very different because you don't have to come into close proximity to be seriously injured
That is
by a gun.
certainly true, Your Honor. And this is it's important to note, a baseball bat, while it does have some potential for danger to an officer, it is its primary purpose is as a sporting implement. It's like a tennis racket or a cricket paddle or a golf club, all of which could be used, to inflict some sort of harm on an individual. But here,
So the officer could have said, "I'd like to talk to you. Don't come any closer. Don't come towards me. Stay back."
that might have been a reasonable response in that sort of circumstance if he had gotten to the, but only if he gets to the level that he believes the person is both armed and dangerous. I think what the Chief Justice is noting is that in almost every single case where short of a reasonable suspicion of criminal activity, a court has allowed an officer to seize an individual or pat first, they're almost uniformly gun cases.
But here's a case, and I know we're using the word seizure and it's a term of art, but this whole event is 30 seconds, right?
30 seconds, yeah, about 30 seconds.
No physical contact between these two, right?
No physical contact.
All we have is stop, keep your hands out of your pockets. I take it the officer takes some steps and he sees what's in that trunk of that car.
He walks the distance to the car and then looks into the car. And as he's doing this, other officers are arriving at the scene as well. There's 3 other vehicles that show up at the scene. Here, as I was noting, the case law is clear that in terms of the facts that we look at, where seizure is, or as seizure as a term of art here, is been allowed where there is no reasonable suspicion of criminal activity. They're uniformly gun cases. They're uniformly high crime areas. They're almost always at night. This, to allow Officer Mann's actions to go under a standard less than criminal suspicion, suspicion of criminal activity, would be a significant expansion of the existing law to this point. As I noted, this is not a high-crime neighborhood. It's not a busy street. The defendant was not engaged in any illegal activity. Multiple officers are at the scene. The bat is not in his hand. The officers know nothing of this individual, don't know any sort of criminal history about him. There's no allegation of threats. Defendant was not near a crime scene or coming from a
How
potential
far
crime
away
scene.
was the bat? You said it was not in his hands.
He had leaned it up behind a pole. It is unclear from the record exactly how far it was.
Well, it was close by.
Close by. But it's hard. The record doesn't actually specifically state how the distance, but it is relatively close by. But as I noted,
You would concede, I take it, that it would be irresponsible for the officer not to follow up and do some sort of inquiry here.
inquiry is certainly allowed, and as Your Honors know, every interaction between an individual, a citizen, and a police officer is not come within constitutional bounds. And the officer certainly, on receiving this report, is engaged in some sort of criminal investigation or investigation of some sort of behavior. He could show up at the scene. He could drive right up. He could ask him, "Are you the individual were you swinging a bat? Why were you swinging a bat? What's going on? Are you okay?" There's nobody else around. There's no other individuals who could potentially be harmed. This would be a very reasonable response, short of actually undertaking a seizure of the defendant, which is what occurred in this case, be it at the criminal suspicion level or at the lower level.
Well, if you have an officer who gets out of his car and then he sees the defendant do something that gives him some concern, what's he supposed to do? Just remain silent?
Well, at that point, what the appeals court found was that was not a furtive gesture, the secondary act. I think the first part of that is, as the Chief Justice noted, is that a bat while has some potential for danger, is not only a lawful instrument, but a normal instrument that's found. It's very, it's pretty common in terms of seeing people in the summer having bats. The second part is any sort of movement. He threw the item away from himself, so it's not as if he reached, as all the cases suggest, or most of the cases in terms of Fraser suggest, the person reaches for something, goes into a waistband, ducks behind a car, and picks something up and puts his hands in his pocket, such as in Fraser, and then refuses an officer's request to remove his hands from his pocket. Here, Mr. Knowles complied with every request the officer made. The only other thing that he did was throw an item into his trunk, an item that Officer Mann testified.
Well, he hadn't made any requests until after he threw. Isn't that true?
Correct. But he had not, his action was not a furtive gesture. It was not an action that Officer Mann could see that it was a weapon or any item. He didn't have any idea what it was.
It could have been a weapon.
There's always a possibility. I mean, there's a possibility it could have been, but at this point, Officer Mann has nothing more. And the appeals court found that, and as did the trial court, in terms of not determining that this particular action was a furtive gesture. As I noted, the case law to this point, in terms of having a situation short of seizure, has developed to require a standard of armed and dangerous. When we don't have seizure, that's a high burden for the Commonwealth to meet. I'd argue that it is not met in this particular case, and urge the court to reverse the decision of the trial judge, order the findings vacated, and reverse the convictions. Thank you.
Thank you, Mr. Crouch. Mr. Solis?
Good morning. May it please the court, my name is David Solit, Assistant District Attorney for Middlesex. If I could, I'd like to address first the reasonable suspicion argument. I'm not trying to convince this court that every time somebody swings a bat that it constitutes disorderly conduct or even reasonable suspicion of disorderly conduct, but that in this particular case, in these facts, that is made out. In this situation, where an eyewitness, by inference, was alarmed enough to call the police and to tell what he or she saw, including the location, the description of the suspect, and the presence of what that person, the caller...
Did the caller get the location right? I thought it was on a
immediately
different
around the
street.
corner, Your Honor.
Around the corner.
The
So
location
it was really
was-
not where she said it was.
Not exactly, but within 10 feet, I think, was the description of the officer. So in the 10 seconds or so that he took to respond, this would be in that immediate area.
Does it make any, because I know you sent us a letter about I'm not sure how to say it, Maligi?
I was pronouncing it Maligi, Your Honor, but I've never
Maligi,
met.
that's probably right. Maligi, which involved a knife.
That's correct. Your Honor.
Do you think that's a distinction that is important, baseball bat versus knife?
I don't think so, Your Honor. I think that, if anything, a baseball bat actually has a greater effective range than a knife does. A knife, in that case, was described as being a total of about 9 inches long. A baseball bat, several feet.
But
Both of those instruments...
The problem with that, Mr. Solit, is that many people walk around carrying baseball bats. I mean, the idea that you've got somebody, walking along swinging a baseball bat seems to me to be a little different than carrying a knife. I mean, just going through my own history, I can't think of the number of times that I've seen anybody walking down the street with a knife. I can't think of times when I've seen people walking down the street carrying a baseball bat.
I guess, Your Honor, I would say that the baseball bat and the steak knife are both perfectly legal implements to possess.
Oh, yeah,
Indeed, many people own them.
that's a different thing.
And many people
a
do
gun may
possess-
be legal, too.
Many people do possess baseball bats on a baseball field, but I think on an urban street corner, 4 minutes before sunset, a gentleman wearing a T-shirt and jeans.
They put them in their trunks. They carry them to baseball fields. They bring them back. They take them out. It's baseball season.
But
It's
the
September.
call was he was swinging it, right?
He was swinging it, Your Honor, and the description in the Maligi case was that he was merely holding it, not thrusting it or waving it at
But
anybody.
the officer
just
shows
holding
up
it.
seconds later that he's not swinging the bat. Maybe he took a couple of swings, couple of cuts. He doesn't see the officer. He puts the bat down by a pole and goes back to his trunk.
There was a question that was posed when we argued this case before by the Chief Justice, Your Honor, where she said, how do you know that he's armed with the bat? And what I would say is that the officer has the ability, indeed the obligation, to protect himself, to put some credence in that caller. The caller clearly called because that person thought he was armed with the bat.
How do we...
Because I think it's
do we-
unreasonable, Your Honor, to presume, and unreasonable to ask the officer to presume, that this person looked out their window, which may well be what happened, saw someone taking a few practice cuts, thought this person enjoys playing baseball, and then decided to call the police.
Well, who was at risk, though? Wasn't this an empty street? No cars, no pedestrians?
For purposes of the reasonable suspicion for disorderly conduct, Your Honor, what Commonwealth v. Mulvey, a case that I did not cite in my brief, but it's 57 Mass Appellate Court 579.
Wait a minute, 57,
Mass Appellate Court
579?
579, Your Honor. In that case, a 2003 case, the court held that the public element of the offense of disorderly conduct is readily met in cases where the prescribed conduct takes place on public streets, which both wholly
this
All
is
right,
not
the
ju-
officer saw no disorderly conduct. He saw nothing.
He did not see it, Your
Nothing.
Honor.
He saw absolutely nothing that would be out of the order.
The issue is whether what was described to him, in the context where it was described to him, would provoke him to reasonably suspect that was what was happening
Seconds
immediately
after
before he
the
arrived.
call, he sees nothing. Why doesn't he just pull up in his car and say, "Excuse me, sir, is there a problem here? We got a call about you swinging the bat."
And, Your Honor, asked the same question. Why couldn't he have asked from the car when we addressed this case in March? I guess what I would say, Your Honor, is that He could have done that. He could have pulled up in his car and shouted out of the window.
If he has concerns, he doesn't know what's going on, why not?
I'd suggest there are policy reasons why you might prefer an officer to get out and speak to somebody face-to-face rather than shouting from a car window. But at the point where he makes the alleged seizure, where the person reaches in their right pocket and throws an unknown object, inferentially in response to the presence of the officer, at that point this officer is already out of his car. He's already made the decision to approach and speak conversationally rather than to shout from his vehicle. That's the point where he has to make that.
And so what is the
moment.
danger with the throwing of something into the trunk?
The
What's
danger
the
is
danger
that
here?
he's immediately beside that open trunk, and if it's a weapon, which someone might discard in order to prevent it from being found on their person, if it's within arm's length, if it's within the wingspan that sometimes the case is described, that if things turn sour in this interaction, that the officer's at risk.
Well, how does the officer describe what was thrown? Was it a big object, something he could hardly see?
He doesn't know what it was. It was obviously of a size that could fit within a pocket, but that could include a .25 caliber handgun, a switchblade knife, any number of things that could harm him, including potentially a projectile.
But the defendant has it in his pocket and is throwing it away, tossing it into the car.
And if he threw it 100 feet away, that would eliminate the danger. But
No, if he threw it 100 feet away, it would increase reasonable suspicion, seems to me.
But I think it would decrease the officer's fear for his safety at that particular moment. Here, the implement was removed from his pocket, but still in a position where the suspect could reach it if he suddenly changed his mind and decided he wanted to grab it. The officer
Mr.
at that
Salat,
point...
can I just go back to, and I understand, that you say you have to give some credence, I think was your language, to somebody who's calling, and the difficulty that I have with that is that we have situations, there was a fairly well-known case in Milton where somebody calls in because they see somebody parked in a driveway and they think that person is about to or has engaged in criminal activity. In other words, you want to encourage citizens to call if they see something suspicious, but all kinds of people think people act suspiciously because maybe they don't recognize the person on the street. It's a very well-known street. They may know just about everybody who comes and goes. Maybe, the person is dressed in an odd way. Surely you can't, yes, the officer responds, but then, as Justice Cordy suggested, you get there's a man carrying a baseball bat walking down a street.
If the report from the citizen, the 911 call or police call, was unreasonable on its face, then of course that would
No,
not
it's not
authorize...
unreasonable. He's swinging a
Suspicious
baseball...
person outside of my house. Suspicious person across the street.
The question would be, obviously, a caller couldn't be wrong, but the officer in this case has to ask himself how reasonable that report is and whether someone in that person's shoes, seeing what they saw, would be unreasonable or out of line in reporting what they
No,
did.
I understand that, but then the officer gets there and somebody's not doing anything.
What the officer has to analyze here, Your Honor, is what that person reported, what brought the police to that scene. Putting yourself for a moment in the shoes of the hypothetical caller, likely a resident of that street, given the first-hand knowledge and the contemporaneousness of the call. If one of us were walking out of our front doors and saw a gentleman in street clothes, jeans, at the foot of our walk, swinging a baseball bat, and instead of going out to walk past him and hope that he ignored us, we turned back into our house and called the police, would we be unreasonable for doing that? Could someone reasonably accuse you of
But
being
you know what the problem
hypersensitive?
with that is? That leaves it to the caller to exercise their own judgment about what looks suspicious. What if they look out and they see a person of a different race? That's the Milton case. And they, just based on that, they say, well, this person doesn't fit in our community. They're suspicious. I'm going to call the police.
If it's
Now,
just based on race, that would be unreasonable.
well, they don't say that. They say there's someone suspicious. And the police respond to a report of someone who's suspicious.
But there was an action that the caller described. The
That's
caller
correct,
didn't
Your Honor.
just say that it was someone suspicious.
And that action that's described, I'd suggest that because of what they did after seeing it, that is, calling the police contemporaneously, that suggests that what the police officer knows and reasonably may rely on is more than just a man swung a bat, but a man swung a bat in such a context that a citizen saw the need to call the police.
Yeah, but the man didn't swing the bat at somebody. That wasn't the report from the citizen. It was just somebody out there swinging a bat. And as Justice Cordy was saying, he could have been just taking a couple of he could have been celebrating the fact that he just hit a triple or a home run or something like that.
I don't think it's likely, Your Honor. I don't think it's reasonable for the officer to assume that someone's been celebrating a home run when they're no longer
Whether
at a baseball
whether
field.
it's reasonable or not, the officer shows up seconds later. The gentleman has got his trunk open. He puts his back over by the telephone pole. He's I mean, what is happening here that is so suspicious that the officer can't make a simple inquiry, doesn't have to get out and sort of make an approach and create a potential situation? If the officer has any concerns, he can stay in his car and say, "Excuse me, sir, we just got a call. You were swinging your bat. Is there something wrong here?"
I don't think it can be defined as unreasonable for the officer, though, to choose to make a face-to-face contact, Your Honor. It shouldn't be a rule that the officer somehow does something
It's not
wrong.
a rule, but if he has some concern for his safety concerning the bat, doesn't know quite what the story is, why can't he do that? Why isn't that a more reasonable approach?
The officer's safety, Your Honor, the concern was enhanced after he had already made that decision to get out of the car.
Mr.
He
Sala,
had the bat.
can I just go, excuse me, can I just go back to your very good hypothetical? I can well understand that if, there's some, are these apartments or single family doesn't really make any difference. Somebody wants to leave their home and go onto the street, and there's a man standing at the end of the, that you don't recognize, one doesn't recognize, swinging his baseball bat. And maybe you call the police, not because you think the man is involved in criminal activity, but you don't feel very safe walking past there. That's fine. I think what we would like to do is to have the police, as it were, make an independent assessment. You come along, the man isn't swinging a baseball bat. He's, in fact, not in the same place where he was reported to have been seen. That's fine, too. People were walking along. He puts the baseball bat down and turns to his car.
What the officers testified, Your Honor, that he was there to do was to do exactly that, to inquire why this person had been swinging the bat. And the suggestion there is that there could have been answers that were satisfactory. If his interaction with this person was pleasant, if it satisfied the officer that the reason for the police call had been a misunderstanding, then the man would be able to go on his way.
Do you agree with Mr. Crouch that there was a seizure?
I don't, Your Honor, but if there was a seizure, it was a de minimis seizure. It was a reasonable seizure under the circumstances.
Does that make a difference for what we do thereafter?
I believe that it does, Your Honor, because the underlying question that this Court has to address is, in these particular facts, was his conduct reasonable? And in the Fraser case and in the Maligi case,
did he have a reasonable suspicion to believe that a crime had been committed, was about to be committed?
I've argued yes, Your Honor, but even in the absence of reasonable suspicion, there are circumstances where an officer can take reasonable steps to secure his own safety. The language that the Fraser case uses is where there's a situation where the officer is his proximity to the defendant was justified. In this case, responding contemporaneously to a call describing a potentially dangerous weapon, I'd suggest his proximity to the defendant was justified, and the steps that he took were steps that were narrowly tailored to minimize the risk to officer safety and to minimize the intrusion to this person. I'd suggest that what he did was analogous to a pat frisk. Classically, a pat frisk, as in Commonwealth v. Silva, has two steps. First, the identification of whether the person has a concealed weapon, and second, if he does, to remove that weapon from the control.
Well, first, you got to have reasonable suspicion to stop the person. And then, are there objective facts that would cause the officer to suspect that the person was armed?
Reasonable suspicion is not the exclusive way that a pat frisk can be justified. There was no reasonable suspicion.
So you don't need reasonable suspicion to stop someone to conduct a seizure.
In certain circumstances, a pat frisk can be justified.
And these are these circumstances. This is armed and dangerous person in the neighborhood, such that
the standard that was articulated in Fraser, Your Honor, was proximity to the defendant was justified. And I'd suggest that the proximity here, that is the police responding to a contemporaneous call of a man with...
So that's all you need is proximity? So in other words, if I walk up to you, I'm a police officer, and I just want to make an inquiry. Geez, I just saw you come down that street, sort of what's going on over there. But since I put myself in proximity to ask you a question, I can then pat search you without reasonable suspicion to seize you or anything of that sort.
I think what the Fraser case articulates, Your Honor, is not just... obviously, a police officer has a right, like any citizen, to walk anywhere. Where the proximity
and to make inquiries and to do all kinds of things. But once they affect the seizure, and stopping someone and pat frisking them is a pretty good seizure.
Well, where it's particularly related, Your Honor, to a duty that an officer would be sworn to uphold, an officer has to respond. We expect them to respond to situations even in the absence of reasonable suspicion. And this was exactly what the trial court...
what you're suggesting is that whenever an officer makes an inquiry, he can do a pat search.
That's not what I'm suggesting, Your Honor. What I'm suggesting is that
he's put himself in proximity. If he has any reason to believe the person might be armed, he can just do a pat search. Whether he has any sort of...
If an officer is responding to a report, which that person believed to be a criminal activity, that is, that they believe they were threatened or annoyed or alarmed by the presence of that baseball bat, he can take certain minimal steps. In this case, what he did skipped directly to the second portion of the traditional pat frisk. The weapon that he saw at first, the baseball bat, was clearly not concealable. It's approximately 3 feet long, I'd infer. So he went straight to the second step. How do I separate the weapon from this person. He could have approached and taken it, but that would require him actually entering the effective range of the bat, putting himself in danger and increasing the chance that he had to use physical force on Mr. Knowles.
Mr.
Instead,
Sut-
what he did
Go ahead, finish.
Instead, what he did was to move Mr. Knowles, with his voice only, move Mr. Knowles away from the weapon. First, from the baseball bat, which was right within arm's reach. Second, from that open trunk containing both the item thrown from his pocket and who knows what else. He did that.
Mr. Solid, just if I can, the Malici case, it seemed to me that one of the critical differences there is that it was the officer who was the person who determined that there was suspicious activity going on. And we know that officers, are very highly trained and often can detect suspicious activity, whether it's based on, in this case, anxiousness, plus he saw a knife, plus he ran away. I mean, it seems to me Malici is quite a long way away. Fraser is a gun. So do you disagree with Mr. Crouch that until this point, that was his last, the last part of his argument, we have permitted this where there has been an armed, meaning of, some kind of violent weapon and dangerous, that we would be really pushing the jurisprudence?
I don't, Your Honor. I believe that the Malici case is closely analogous to this. In both cases, there are weapons that clearly can be dangerous but are not weapons that are prohibited, are legal to possess. You can buy a steak knife at
Yes,
Crate
but
and
you
Barrel.
don't usually carry, on a busy street, a knife.
And I'd suggest, Your Honor, that people don't usually swing baseball bats on the sidewalk
think-
away from a baseball field. That-
I'm not sure that's
I'm
true.
not sure that that's correct. In any case, your time is up.
I just
Justice
had one.
Watson.
Does community caretaking have anything to do in your analysis of this case?
I'd suggest that it does, Your Honor. That the
And where does
community-
it come in?
that community caretaking, though the cases, as Mr. Crouch articulated before, largely deal with stopped motor vehicles, that it also encompasses a need to protect the safety of the public. In some of the community caretaking cases that deal with motor vehicles and rest stops, even where there is no pending criminal activity, that is, where the vehicle isn't moving, the officer is justified in making sure that somebody who might be impaired doesn't get back on the road.
So
If
what does
when-
it justify here?
Here, as Justice Cordy's pointed out, when the officer does arrive, he's not swinging that bat anymore. But if there's something wrong, if he's angry at somebody, if he's mentally unstable, if he was swinging that bat in a violent way that threatened people, and the officer, seeing that nothing is happening at the moment, 10 seconds later he arrives, decides just to cruise on down the street, he would be in derogation of his duty to not find that out, because this is something that might be right about to flare back up. There he has an obligation to find out what was going on and make sure that the community is not at risk.
Thank you, Mr. Sonnet.
Thank you.